morning, and thank you very much for the kind introduction. I have to say it's always a pleasure to be back in Canada, and after 8 years now working on refugee issues in Europe, out of Brussels, a number of the qualities which are so special about Canada are more obvious to me than ever. One of those qualities is very much in evidence here, and that is the tremendous, and I really can't emphasize this enough, the tremendous vibrancy of civil society, of the NGO sector in Canada, and the extent to which the refugee and immigrant community is engaged in discussions about asylum and migration. Over the past 8 years, I can't tell you how many conferences about asylum and migrations I attended all over Europe, north, south, east, and west. And from conference to conference, the thing that struck me the most was the near total absence of refugees and migrants from the debates. European experts gather all the time to talk about refugees and migrants, but they very rarely talk with refugees and migrants. So I'd like to congratulate the organizers, not just for putting together this truly interesting conference, but also to congratulate the organizers and Canada more generally for continuing to lead the way, because I believe you do lead the way on diversity and inclusiveness, and Europe would have a lot to learn from Canada in that regard. Now, I'm starting this presentation today with a number of challenges, not least of which is following on the heels of Jim Hathaway, Deborah Pressé, and Paris Aristotle. It's also a challenge for me because it's the very first time in 32 years, because I was 32 years with UNHCR, so you can all now mentally calculate how old I am. But it's the first time in 32 years that I'm speaking in my own voice and not for the institution. So on the one hand, that's very liberating. On the other hand, it's a little bit frightening. Another challenge is that unlike all the previous speakers, I don't have a PowerPoint, so you don't have to stare at the screen, but you will have to engage your brains. Further challenge, I'm not going to talk very much about resettlement. And then finally, perhaps the most important challenge is that I'm acutely aware of the fact that I'm the only thing standing between you and your lunch. So I'm going to ask you to bear with me, or to bear with us for another hour or so as I try to transport you from the North American continent to Europe for a look at some of the challenges, and I'm going to be really selective, some of the challenges that Europe is facing in the field of refugee protection. Now, when Chris got in touch with me and invited me to the conference, he asked me to speak specifically about the European Union's efforts to establish a common European asylum system. And just a reminder, the European Union now consists of 27 member states, has a population of 500 million people, countries ranging from tiny Luxembourg with 500,000 citizens to Germany with 85, 86 million. So it's a very diverse union. You might ask, sitting here in Vancouver, why Europe's approach to asylum matters to Canada. After all, Europe is pretty far away. I'm not quite as jet-lagged as Paris, but it's far enough away, so it takes a few days to recover. But the reality is that 3/4, 75% of all asylum applications in the industrialized world are lodged in Europe. Last year, the 27 EU member states received nearly 3 times as many asylum applications as Canada and the United States combined. More asylum applications were lodged last year in tiny Belgium, where I live, in Belgium alone, than in Canada. And Canada is 300 times the size of Belgium in terms of land area, and 3 times the size of Belgium in terms of population. But I would say that Europe's importance to refugee protection is not just a matter of numbers, although it is also a matter of numbers. Over the past 12 years, the European Union has worked to develop what is now the world's most sophisticated regional refugee law regime. And it goes a little bit to what Jim was talking about. an effort by states to get together, to work together, to coordinate, to take a harmonized approach. The EU, the European Union refugee law regime is now, in my opinion, the most highly developed refugee law regime in the world, and the content of the laws goes well beyond the 1951 Geneva Convention. In addition to the EU's refugee law, which I will talk about a little bit in a minute, Europe has 2 regional courts which address asylum matters, and there are 2 European Union agencies whose work has a direct impact on asylum seekers and refugees. And Europe, of course, geographically is closer, much closer to most regions of origin of refugees than, say, Canada or the United States. And finally, perhaps the most important reason for talking about Europe, and Paris mentioned this, we know that in a globalized world, the laws and policies and practices and rhetoric adopted in one region of the world tends to be scrutinized and often adopted by other regions. The world is getting smaller and smaller, and countries are looking at what each other is doing. Now, my basic premise is that in the area of refugee protection or of asylum, as is true for some other aspects of the European endeavor, the ambition has not been matched by the reality. Still, the goal of establishing a common European asylum system, of harmonizing the laws and policies and practices of 27 countries, this goal is still a very attractive one. It's attractive not only because a common approach to asylum makes sense in a region where free movement of people is the rule, it's also because the European Union, the history of the European Union, is one of a commitment to human rights and fundamental freedoms. Now, it was in the late 1990s that the idea of establishing a common European asylum system was first articulated. When this idea was first voiced, the European Union had 15 member states. Today it has nearly doubled in size to 27. Croatia is going to become the 28th very soon. And it is remarkable that 27, soon to be 28, sovereign states have agreed to harmonize their laws and policies in the area of asylum, because nothing, and I think we heard this from both Jim and Paris, nothing is closer to the sensitive core of state sovereignty than deciding who is allowed to enter a country and, more importantly, who is allowed to stay. And for those of you who have been around a while, just think back and remember how difficult and controversial it was and how long it took to conclude the Safe Third Country Agreement between just Canada and the United States, and then imagine what it's like when more than 24 countries with very different cultures, much more different than the United States and Canada, very different cultures, legal systems, traditions, and experiences with asylum and migration. Imagine how difficult it is when they are trying to harmonize their laws and policies. The starting point for the development of the Common European Asylum System, as it is called, really is October 1999, when a special summit meeting, heads of state and government, met in a little town in Finland called Tampere to talk about matters of justice and home affairs. It was actually the very first time that there was a summit meeting to discuss things like refugees. And at that meeting, the heads of state and government pledged to develop the European Union as what they called an area of freedom, security, and justice. All European Union citizens, they believed, should benefit from the Union's shared commitment to human rights, to democratic institutions, and to the rule of law. And it was this concept of an area of freedom, security, and justice which led the European Union to define refugees and asylum seekers, and you will appreciate this in Canada, to define asylum seekers and refugees as only as people who come from outside the Union. So they defined asylum seekers and refugees as people who come from outside the 27 member states. And that has particular resonance in Canada because of the problem of Roma from EU member states, Hungary and the Czech Republic in particular, who are applying for asylum here, in part because they cannot get asylum within their own union. But the leaders believed, the EU leaders believed, that there would be no need for EU citizens to seek protection as refugees because by definition they lived in an area of freedom, security, and justice. Of course, when they made that decision or determination, the EU was much smaller, and it was before the enlargement to countries like Hungary, the Czech Republic, Slovakia, Romania, Bulgaria. So one could ask whether they would make the same determination today. Some observers at the time, including UNHCR, raised questions about this approach, about defining refugees as people coming from outside the Union, seeing a possible conflict, and I personally believe there is a conflict, seeing a possible conflict with Article 3 of the 1951 Convention, which is the non-discrimination clause, which says that this convention will never be applied in a way that is discriminatory according to nationality. The EU leaders back in 1999 also committed themselves to making sure that this area of freedom, security, and justice would not benefit just the Union citizens, because they said it would be contrary to Europe's traditions to deny basic freedoms to people, and I quote from the Summit Declaration, to people whose circumstances lead them justifiably to seek access to our territory. And for that reason, they decided to develop common policies on asylum and migration. The aim, they said back in 1999, was an open and secure, so those two things that Paris also talked about, an open and secure European Union committed to the Geneva Convention and other human rights instruments and able to respond to humanitarian needs on the basis of solidarity. They reaffirmed in the Summit Declaration the importance of the absolute right, the absolute respect of the right to seek asylum, and they agreed to work toward establishing a common asylum system based on the Geneva Convention. But as politicians often do, they didn't go into very much detail. They didn't explain back in 1999 what they really meant by a common European asylum system. They didn't explain how much responsibility would be retained by individual states, and they didn't say whether they envisaged eventually the development of a European Union-wide asylum authority. Probably it was very deliberate to leave it so vague. Probably it was precisely this constructive ambiguity which allowed the project to proceed at all. They did sketch out already back in 1999 the key elements that they thought a common system should contain. And at a minimum, they said there needed to be a mechanism for determining which of the member states would be responsible for examining any given asylum application. So a system for saying which of the 27 countries was responsible, Chris, for your asylum application. They said there had to be common minimum standards, conditions, for how asylum seekers would be received, and common standards for a fair and efficient asylum procedure. And there also had to be agreed rules on the recognition and content of refugee status and what they called subsidiary forms of protection, other forms of protection. So like the area of freedom, security, and justice as a whole, the common asylum system was built on a foundation of mutual trust. The leaders expected that each member state would be able to assume that every other member state would fulfill its responsibilities toward asylum seekers and refugees in a more or less equivalent way. That was the idea. And mutual trust is the basis of a lot of what goes on in the European Union. The states assume that they can trust each other to fulfill their responsibilities. Now, what has happened since then? That's the reality part. Well, I have to say that the accomplishments since 1999 have been quite considerable. The EU has adopted laws in the area of refugee protection which bind all 27 member states. So these are laws, these are supranational laws, but which bind all the 27 countries, and they go far beyond the rather limited content of the 1951 Convention. The EU laws, there are 3 laws which form the core of this common system. One is a directive. A directive is another word for a law in EU speak. Directive on reception conditions, which sets out very detailed minimum standards for how asylum seekers are to be treated. It covers things like housing, healthcare, information which has to be provided to asylum seekers, access to education, treatment of especially vulnerable people like unaccompanied minors, victims of torture. These might seem obvious to you, but if you've read the Geneva Convention, you know that there's nothing in the Geneva Convention which says how states have to treat asylum seekers beyond the prohibition of refoulement. So this was really quite revolutionary. The second law is the Asylum Procedures Directive, and as its name indicates, it stipulates how asylum procedures are to be conducted. Things like the provision of legal aid, the provision of interpretation, the requirement of a personal interview. These are also areas that are not covered at all by the Geneva Convention. The Geneva Convention doesn't say anything about what an asylum procedure should look like. So it was quite revolutionary. And the third building block, which is known as the Qualification Directive, defines who is eligible for protection and what the content of that protection is. And that directive also goes well beyond the Geneva Convention, because it not only says refugees as defined by the Geneva Convention get protection in the European Union, but it establishes another category of people who are protected, and they are called beneficiaries of subsidiary protection. So a little bit like the Canadian approach when the ERPA was first adopted, it extended the sphere of protection from convention refugees, stricto sensu, to people with broader protection needs. Subsidiary protection extends to people who face a real risk of serious harm in their home countries for reasons other than those set out by the Refugee Convention. And it has principally been a tool to protect people who have fled indiscriminate or generalized violence in situations of international or internal armed conflict, but who can't demonstrate a link to one of the 5 grounds in the Convention, but who have left simply because of the breakdown of law and order at home. Now, from the perspective of the average citizen, of course, a common European asylum system means not only the establishment of common standards for the treatment of asylum seekers and refugees, but also the consistent implementation of these standards in practice, and a more equal sharing of responsibility for refugees across the Union. And these important goals have not yet been achieved. And the fact that they have not yet been achieved is what is creating tremendous tensions today. I said earlier that when discussion about the common asylum system began, the European Union had just 15 member states. In 1999, those 15 member states received 367,000 asylum applications in that 1 year. So it's a large number, 367,000. But 90%, so almost all, of those applications were lodged in just 6 of the 15 member states. And you can probably guess which 6 states those were: Germany, the United Kingdom, the Netherlands, Belgium, France, and Austria in that order. By 2011, last year, the Union had 27 member countries, so it had nearly doubled in size. The number of asylum applications had fallen off sharply. Last year, there were just 277,000 applications in the 27 countries, so fewer applications, more countries. But the applications were still very unevenly distributed. In 2011, 80% of applications were still lodged in just 6 member states. Again, France, Germany, Belgium, and the United Kingdom were in the top 6. The Netherlands and Austria, thanks to their restrictive measures, had been replaced by Sweden and Italy. I think that it is, to a certain extent, this unequal distribution of asylum applications across the European Union which has created space, or given space, for right-wing political parties in the most affected countries to argue that illegal immigration and abuse of asylum are out of control, and to imply, and in some cases explicitly to allege, that the European Union is at fault for not controlling its external border. There are today more extreme right, you could even say neo-fascist, political parties, populist parties represented in European parliaments than at any time since the Second World War. And this is really a frightening phenomenon. These parties espouse racist, xenophobic, and very often anti-Islamic agendas. And their signature issue is not only their opposition to immigration, but their opposition to the growing powers of the European Union. Voices rejecting immigration have been strengthened, I think, by recent comments by people as prominent as German Chancellor Angela Merkel or British Prime Minister David Cameron, to the effect that multiculturalism has failed in their countries. These right-wing parties oppose, they really vociferously oppose freedom of movement within the European Union, and many of them advocate for re-imposition of border controls between the member states as a way of controlling irregular or illegal immigration. Now, it was precisely the disappearance of borders between the member states which made a common asylum system necessary. The absence of border controls means that people, and people include asylum seekers and refugees, can travel, say, from Malta to Finland, so all the way from the south to all the way to the north, or from Slovakia in the east to Belgium in the west, without being checked by any authority. Although it is important, I think, to mention that both the United Kingdom and Ireland opted to remain outside of this borderless zone, and that Cyprus, Bulgaria, and Romania have not yet been permitted to enter it. But still, with free movement among 22 of the 27 EU member states, and this free movement is also extended to Switzerland, Norway, and Iceland, with free movement, governments worried that asylum seekers would gravitate, as indeed they have done, to those countries perceived to have the best asylum systems, or to those countries where family members or a community of co-nationals are present. And they worried that asylum seekers would try to maximize their chances by lodging several claims, multiple claims in different countries. And that's when this term, this really odious term, asylum shopping, took hold with all of its negative connotations, and the term is still very widely used by officials as a synonym for abuse. So for these reasons, a mechanism was developed to identify the state responsible for examining any given asylum application. And I'd like to talk a little bit about that mechanism, because it's that mechanism, I think, or the problems associated with that mechanism which may bring down this common system. This mechanism is known by a kind of shorthand name. It's known as the Dublin II regulation. It has a much longer name. The Dublin II regulation sets out criteria according to which responsibility for examining an asylum application is determined. The Dublin II regulation does not try at all to ensure that responsibility for asylum is shared in a fair or balanced manner. It just sets out the criteria for determining which state is responsible. 31 countries, all 27 EU member states plus Iceland, Liechtenstein, Norway, and Switzerland now participate in this arrangement. So it's really a very, very broad arrangement. If you say, it's like the US-Canada Safe Third Country Agreement, but among 31 countries. And according to the criteria in the Dublin regulation, the responsible state is generally the country which the asylum seeker first entered, with some exceptions, for instance, for cases of unaccompanied minors or family reunification. So, for instance, let's say a Chechen asylum seeker crosses from Ukraine, which is not an EU member state, into Slovakia, which is an EU member state, and then she manages to make her way through, let's say, Hungary, Austria, Germany, to Belgium. Belgium is very attractive to Chechen asylum seekers because of its jurisprudence on Chechens, because there's a large community. Belgium is entitled to send her back to Slovakia for determination of her claim. If, for instance, a Somali refugee asylum seeker arrives by boat in Malta, from, let's say, Libya, leaves Libya, gets on a smuggler's boat, lands in Malta, and then, because of free movement, gets on a ferry, travels to Italy, goes all the way up, let's say, to Finland. Finland is entitled to send him back to Malta. It's a long way if you look at a map from Finland to Malta. Now, you might ask, how does Finland know the Somali first arrived in Malta, and how does Belgium know the Chechen woman first arrived in Slovakia? They know because the Dublin system is bolstered by a huge database of fingerprints known as Eurodac. And participating states are required to enter into this database the fingerprints of all non-European Union nationals, so they don't fingerprint the EU nationals, non-European Union nationals who are apprehended on their territory after crossing the border in an irregular manner, whether by land or by air or by sea. So if the fingerprints of the Somali in Finland match fingerprints in the database, Finland is entitled to send the person back to Malta. Similarly, if the fingerprints of the Chechen in Belgium match prints taken in Slovakia, Belgium can send the person back to Slovakia. This system has led to a real spiral of desperate behavior on the part of asylum seekers, and I think also on the part of states. I think states are almost as desperate as the asylum seekers. Asylum seekers have taken to burning their fingertips in an effort to erase their fingerprints. It's very common, in order to avoid being sent back to the country they first entered, the country that is considered responsible for their claims. States have then taken to detaining asylum seekers with burned fingerprints until the prints grow back, because they do grow back, so that they can secure a match which would enable them to send the claimant to the responsible country. Now, this whole system is based on the assumption that the asylum seekers will have equal chances of being recognized as refugees and being protected, no matter where in the European Union their claims are considered. In other words, the system is based on this foundation of mutual trust. Each member state is, or perhaps I should say, until recently, each member state was entitled to assume that every other member state would fulfill its obligations under European and international law. Countries have built up huge administrations to manage this Dublin system. They spend considerable sums, not only on these administrations, but on detaining asylum seekers so that they can return them to the responsible state. And as we heard from Paris, detention is very expensive. They spend huge sums moving people around, usually by air, from one end of Europe to another, often with police escorts, which we know is also very expensive. And no one has ever even attempted to quantify the fiscal cost of this system, much less the human cost of the system. But I think that what might bring down the system is not its cost, but even in the current time of economic crisis, and even though the cost is no doubt very high, I think what might bring down the system is the revelation, if I can use an old metaphor, that the emperor has no clothes. And I'll explain what I mean by that. Europe has two regional courts. I'm sure you know this. The European Court of Human Rights in Strasbourg, which is an institution of the Council of Europe, and the European Union's own Court of Justice in Luxembourg. Both of these regional courts have recently called this Dublin system into question. Both courts have stated clearly, really clearly, that participating states may not simply assume that other participating states will abide by their obligations under European and international law. And just as Greece may cause a collapse of the Eurozone, I think it's the situation of migrants and asylum seekers in Greece which may bring down the common European asylum system, or at the very least create a need for root and branch changes in the system. According to estimates by the European Union's border agency, Frontex, the overwhelming majority of people who cross into the European Union in an irregular manner now do so across the Turkish-Greek border. So if the Dublin system were to function as intended, Greece would be responsible for the overwhelming majority of asylum applications in the European Union. Yet Greece, even though it joined the EU back in 1981, does not have, never had, in my opinion, a functioning asylum system. Until the 1990s, UNHCR handled refugee status determination in Greece and resettled refugees out of Greece, including, by the way, to Canada. In the second half of the 1990s, UNHCR stopped its mandate operations in Greece, arguing that there was no reason to substitute itself for a European Union member state, a state that's party not just to the 1951 Convention, but also to the European Human Rights Convention. UNHCR stopped resettling refugees out of Greece in the belief that if protection were needed, it should be available in Greece. Very logical and theoretically correct. The problem was that protection was not available in Greece. The Greek asylum procedure was and remains dysfunctional. The registration and status determination systems were wholly inadequate, reception arrangements non-existent, no settlement or integration support for the handful of people who got refugee status. And these deficiencies have been documented for the past 25 years. This is nothing new. But as long as the number of asylum seekers in Greece was low, the situation could be ignored. That changed really all of a sudden in around 2008. And it changed as a result of the deal that the then Italian Prime Minister Silvio Berlusconi made with Libya. You might remember that in 2008, Berlusconi concluded a deal with Colonel Gaddafi, and all of Europe was then courting Gaddafi. I mean, how times have changed. But he concluded an arrangement with Gaddafi that would allow the Italian Navy to intercept migrant boats in the Mediterranean and forcibly return people to Libya. This deal with Libya was sharply condemned by human rights advocates, lots of human rights advocates, including the UNHCR and the UN High Commissioner for Human Rights. The European Union, on the other hand, remained strangely silent about it, didn't say anything about the compatibility of this arrangement with European Union law or with international law, although it clearly violated both. No doubt hoping that Italy's deal would stop the flow of migrants and asylum seekers from North Africa to Southern Europe, but it didn't. As we heard from, I think, both Jim and Paris, flows, I think Paris used the analogy, you know, if you squeeze the balloon here, it pops out there. That's precisely what happened. So the flows across the central Mediterranean from Libya to Italy and Malta were stopped, and the flow shifted almost immediately from the central Mediterranean to the Turkish-Greek border. Although no one knows exactly how many people cross into Greece now in an irregular manner over the Turkish land border at Evros, the river Evros, according to European Union sources, by 2010, 90% of all apprehensions for illegal crossing into the EU took place across that border. That's a stunning figure. And under these circumstances, the shortcomings of the Greek asylum procedure really couldn't be ignored anymore. UNHCR and others like MSF, Human Rights Watch, etc., Amnesty, all documented the desperate situation of asylum seekers and refugees in Greece. And really, I mean, it's hard to describe, but conditions in detention centers at the border with Turkey, conditions in a detention center at the Athens airport were nothing short of horrific and still are. There was no reasonable, reliable process for lodging an asylum application, and even those few people lucky enough to lodge an application had no real chance of getting protection. Just to describe the situation to you, in 2007, Greece registered 25,000 new asylum applications and only 8 people got refugee status. That year, UNHCR, which rarely points the finger at individual countries, my team reviewed 305 case files in Greece of applicants coming from Afghanistan, Iraq, Somalia, Sri Lanka, and Sudan, all, I think we would all agree, all nationalities that have high recognition rates in other countries. All 305 decisions were negative. None contained any reference to the facts of the case. There was no legal reasoning in any of the 305. The wording of the decisions was identical in all 305 files. All used standard wording saying that the applicant had left his or her country to seek improved living conditions. Asylum seekers were living, still are living, on the streets of Athens and other cities, were and still are frequently the target of racist attacks. I remember one incident where A little girl from Afghanistan was blinded and her brother was killed by a grenade. They were rummaging in a garbage bin for food, which is what a lot of migrants do in Athens, and right-wing groups had planted a grenade in that bin, and one child was killed and the other blinded. And then another EU country stepped in and evacuated that child for eye surgery, but it was by then a bit late. So in the face of this crisis in Greece, UNHCR appealed to European governments not to send asylum seekers back to Greece under this famous Dublin regulation. But governments continued to do so, citing this principle, this fundamental European principle of mutual trust, saying, we believe Greece, as a partner in the Union, will do the right thing. This changed in January of 2001, when the European Court of Human Rights issued its ruling in a case which is known as MSS. MSS were the initials of an Afghan man, an asylum seeker, case known as MSS versus Belgium and Greece. I should just remind you that the European Court of Human Rights, located in Strasbourg, is not a European Union institution. It's an institution of the Council of Europe, which has 48 member states. It assesses the compliance of Council of Europe member states with the European Convention for the Protection of Human Rights and Fundamental Freedoms, which was actually adopted in 1950, so before the Refugee Convention. But a key element of that convention is its Article 3. Article 3 prohibits torture and inhuman or degrading treatment or punishment, and that has been interpreted by the court to encompass the sending of individuals to countries which are guilty of such behavior. So MSS, as I said, was an Afghan man. None of us had any doubt that he was a refugee. He had worked for international forces in Kabul. He had come under threat because of his association with international forces. And in early 2008, he fled through Iran and Turkey to Greece. He didn't apply for asylum in Greece, but he was caught by the police. His fingerprints were taken. He was detained for a week, and then, like everybody else, he was released and told to leave the country. He did. He traveled onward. He arrived in Belgium in early 2009, where he immediately applied for asylum. And when Belgium entered his fingerprints into the database, they saw that he had been in Greece. Belgium ignored information from UNHCR about the situation in Greece. They actually ignored a written request from our office to refrain from sending him back to Greece. They argued in their response to us, to UNHCR, that there was no reason, they said no reason to suspect that the Greek authorities would fail to honor their obligations under EU law or under the Geneva Convention, and they sent him back to Athens airport under police escort, actually after a few failed attempts to have him depart on his own. On arrival, Mr. MSS was placed in the immigration detention facility at the Athens airport, but probably because of interest in his case coming from Belgian NGOs, he was released after 3 days and told to report to the police headquarters in Athens, where all asylum applications have to be lodged. But at police headquarters in Athens, the authorities register applications only 1 day a week, usually on Sundays, and they register only about 20 or 25 applications each time, whereas up to 2,000 people queue up on those days to register. In fact, people start to queue up the night before in the hope of being among the lucky few. Mr. MSS knew that as a single male, he would have really little chance of getting to register, because what actually happens is the police come and they pull out of the line people they think look vulnerable, so women alone with children or kids alone, but a single man would have little chance. So he didn't even bother to try, and as no assistance was available, he went to live in a park in central Athens along with other homeless asylum seekers and migrants. His lawyer in Belgium, a very young lawyer, who was actually had been assigned as his pro bono legal aid attorney when he was in detention in Belgium. He's a Belgian of Moroccan origin. He took the case all the way up through the Belgian system and finally appealed to the European Court of Human Rights in Strasbourg, which decided to hear the case. And the court in Strasbourg, the European Court of Human Rights, found both Belgium and Greece guilty of violating Article 3 of the European Human Rights Convention. UNHCR was an intervenor in the case, and for the very first time in its history, I'm quite proud to say that we did this, we presented oral arguments before the court alongside our written intervention. And in its decision, the court relied very heavily on information provided by UNHCR about the situation in Greece. And I actually think that had we not intervened, the court might have been less courageous. The court said that the Belgian authorities and I'll use their words, knew or ought to have known about the deficiencies in the Greek asylum procedure. Belgium, the court said, could not simply assume that an asylum applicant would be treated properly in Greece. Belgium had to verify, the court said, how Greek legislation was applied in practice. And had the Belgian authorities done this, the court said, they would have seen, and this is a quote, they would have seen that the risks the individual, Mr. MSS, faced were real and individual enough to fall within the scope of Article 3 of the European Human Rights Convention. Now, this decision has shattered the notion of mutual trust on asylum, and it has significantly weakened the foundation of the common European asylum system. By stating clearly that violations of Article 3 of the European Human Rights Convention occur within the European Union, it undermines the very premise, I think, that the EU is an area of freedom, security, and justice. Meanwhile, similar cases were making their way to Europe's other regional court, the Court of Justice of the European Union, which is located in Luxembourg, and which, as I said earlier, assesses the compliance of EU member states with EU law, including asylum law. The EU court had agreed to hear cases referred by Irish and British courts, which were joined together for the purpose of the EU court's consideration, and these cases concerned Afghans, Algerians, Iranians, I think that was all, who had been ordered back to Greece from the UK and Ireland. And a lot of us wondered how the EU court would approach these cases, and many of us felt that it was going to be very difficult for the EU court to disagree with the European Court of Human Rights. These are two separate jurisdictions, but of course they watch very closely what each other does. In the event, the EU court did not disagree with the European Court of Human Rights, and in its judgment, which was issued at the very end of last year on the 21st of December, the Court of Justice of the European Union took a very similar position. It said that there could be no conclusive presumption, I mean, this is really quite shocking, no conclusive presumption that the member state, which the Dublin regulation designates as responsible for an asylum application, there can be no conclusive presumption that that country will provide the protections set out in the EU Charter of Fundamental Rights. I mean, it really takes one's breath away. So, since there can be no conclusive presumption, member states may not transfer an asylum seeker to the responsible member state if the individual could face a risk of being subject to inhuman or degrading treatment there or refoulement. And the court said, like the Strasbourg Tribunal said, that the member state has to first check whether the responsible member state actually observes fundamental rights, and if not, the authorities are bound to assume responsibility for the application themselves. Now, in my opinion, these two judgments, Strasbourg and Luxembourg, are the most significant developments since the decision to establish a common European asylum system. The finding that it cannot be assumed that EU member states will comply with their human rights obligations raises very broad questions, not only about the asylum system, but about the area of freedom, security, and justice itself. So you might ask, what happens next? And I'm not sure what happens next. I think that as long as the ban on returns is limited to Greece, the situation can probably be managed. Other EU countries, albeit reluctantly, are taking responsibility for asylum seekers who've entered the EU territory through Greece before making their way to other countries. But questions are being asked and increasingly brought to the courts about the compliance with European law of the asylum systems in other countries. In Hungary, for instance, there are questions being asked about whether mandatory detention of asylum seekers complies with European law. There are questions being asked about the adequacy or inadequacy of reception arrangements in Italy. There are questions being asked about the independence of the asylum procedure in Slovakia. So if Europe's courts stop returns under the Dublin regulation to countries other than Greece, my question is, and I don't have an answer for it, can this system survive? How has the European Union responded to this potential crisis? I actually think, well, I know from talking to our counterparts in the Justice and Home Affairs Division that it has been really very, very difficult for them. How have they responded? On the one hand, I think quite positively by encouraging practical cooperation on asylum among member states. to try to help them to improve their systems. So in 2010, the European Union created a new agency called the European Asylum Support Office, based in Malta, which is not too convenient if you have to travel regularly to Malta. But anyway, the support office has as its underlying aim to contribute to the establishment of a common European asylum system, and it has defined its most urgent task as being to bolster the Greek asylum system. At the same time, like most industrialized countries, including Australia and Canada, the EU has redoubled its efforts to combat irregular migration. Already in 2004, it established an agency called Frontex, which is short for the French Frontières Extérieures, which is the European Agency for the Management of Operational Cooperation at the external borders of the member states. And in 2012, you won't be surprised to know that the budget of Frontex, the border control agency, was 7 times the budget of the Asylum Support Office, and Frontex has been given a vastly expanded mandate to initiate and implement border control actions, to acquire hardware, helicopters, boats, you name it, despite questions about the agency's accountability, its transparency, and its respect for human rights. The EU has also strengthened its cooperation with countries outside the Union, including both countries of origin and of transit, in order to discourage, deflect, deter irregular movements toward the EU. But we know, and we heard from Paris, I think, that the harder it becomes for refugees and asylum seekers to reach asylum countries through legal means, the better the market becomes for smugglers and traffickers. And finally, the Union has invested heavily, but without much success, as we also heard from the Australian example, in enforcing the return of failed asylum seekers to their countries of origin or transit. So these efforts, even if they are successful, are not going to resolve the underlying problem of the absence of a mechanism to ensure that responsibility is shared in a fair way. Responsibility for refugees is shared for a fair way within the European Union. And my question is really whether states will be willing to move on to the next level and establish a truly supranational system for the management of asylum in the European Union. Will states be willing to give up their sovereign powers, or how much of their sovereign powers would they be willing to give up? Can we imagine, for instance, the creation of an EU-wide asylum authority that would replace national authorities? Can we imagine an EU-wide asylum tribunal? I don't know. But I have no doubt that something will have to be done to establish a real responsibility sharing mechanism. For the time being, I am afraid the current crisis is going to prevent any positive new initiatives in the area of asylum. We'll probably have to wait quite some time for further advances. But I just wanted to say before closing that it's going to be a particular disappointment if this current crisis also prevents progress in the area of refugee resettlement. And I think it might. Let me just explain. I think when Deborah made her presentation, she mentioned that the contribution of Europe to refugee resettlement has been very modest for quite some time. In 2010 and 2011, all 27 EU member states together provided just 6.5%, more or less, of resettlement places worldwide. That was 4,700 in 2010 and just over 4,000, I think, in 2011, so considerably less than either Canada or Australia. UNHCR has continued to press the European countries to engage more in resettlement. IOM has done the same. NGOs have carried out countless capacity building projects. They've brought government officials and NGO partners to Canada many times to show them how resettlement can be done. The European Parliament and the European Union's executive arm, the Commission, have also advocated for resettlement. And you would think it would be an easier political sell than asylum for all the reasons we have discussed these last days. There should be more political space for resettlement. But I'm afraid that the reluctance of EU member states to engage in resettlement reflects something much more profound about how European countries view themselves. It reflects, I'm afraid, their really deep-rooted ambivalence about pluralism and multiculturalism. Many European countries still see resettlement as an immigration matter and for the most part do not perceive themselves as countries of immigration, even though there is plenty of evidence to the contrary. So just a maybe final reflection, where is EU refugee policy headed then? Is the glass half empty or is it half full? It's a very difficult time to make that assessment. The current economic crisis, not just the euro crisis itself, but the broader economic crisis, puts discussions about refugee protection at the very, very back of the political agenda. And I think that the willingness to take a truly European approach to asylum and migration is linked to the success of the broader European project in the areas of political and economic union. And I fear that policy in the area of asylum and migration may be a casualty of the current broader crisis in the EU. Which means I think that all of us as advocates have to work harder to keep the protection of refugees on the political agenda, not protection from refugees, which is always on the political agenda, but protection of refugees. And we need to do more. We need to work harder to demonstrate why a strictly national, unilateral, self-interested approach is bound to fail. I think Jim Hathaway explained that in a really clear way. We have to all do more to explain to fellow citizens and to politicians that in an interconnected world there is no alternative to international cooperation and solidarity on refugee matters. We know that in other fields like trade, but it's also true in the refugee protection field. So my hope is that the European Union will overcome its current difficulties and return to the original project of establishing a truly common asylum system. But only time will tell whether the Union moves in that direction or back in the direction of 27 individual systems with each country jealously protecting its own interests and its own sovereignty. So I guess we'll have to come back, Chris, in maybe 5 years and see which way it went. And I thank you very much for your attention.